May I please, Lordship? Item number 11 may kindly be jumped because senior counsel, Dr. R.C. Borkhata, he is in bereavement. He lost his sister. That is why he is not in a position to attend today.
For how long you want
Matter
adjournment?
may kindly be listed on 18th.
Huh? The
18th.
listed we can't say. How many days adjournment?
This for 1 week. After the 24.
All right. On the prayer of learned counsel for the petitioner, hearing of this matter stands adjourned till 24th of March 2025. List accordingly.
The consular of the respondent, my lord, the victim is item number 14. It can be taken after 2 weeks, my lord.
You are for the petitioner.
I am for the
On the
petitioner.
prayer of petitioner's counsel, hearing of this matter stands adjourned for 2 weeks.
No, my lord.
Lord, I pray for listing of a motion matter for Monday, Lordship.
What is the matter about?
Lordship, initially, Lordship, he was engaged as a master role worker.
Hmm.
Then he was allowed to work as a work charge khalasi and thereafter regularized to a personal post. He is continuing in the same post, Lordship, without promotion since last 32 years.
Hmm. So what is the urgency? Why Monday? Why not Wednesday?
Any
And motions are not listed.
listed, Lordship,
Then
but
why are you mentioning, misusing, abusing the
Lordship,
money?
either on Wednesday or Friday, any day.
No, it's rejected. These are not matters which require urgent. Don't mention unless it is necessary.
Lordship,
Otherwise, the mentioning will be withdrawn. Then you will not be able to mention even urgent cases.
Lordship.
It will come in its usual
Lordship.
course. Yes.
Prayer for listing of a matter, my lord. There is a vacancy to the post, my lord.
Hmm.
One of the posts, my lord. I being eligible, my lord. I have not been considered, my lord. It's for admission, my lord.
That you have to file an IA, otherwise suddenly how can this prayer be considered? The fact that there is a vacancy, is it on record?
My lord, in the writ petition, I have stated, my
Then
that I may be considered for the same post.
second week of April.
Deeply obliged. One more,
Hmm?
one more is there, my lord. My lord, I am the wife of a person who has died now, my lord, who was serving in PRPA. Now, my lord, what has happened is that there was second marriage which had taken place.
What is that you want?
My lord, listing, my lord, this is also admission matter.
Second week of April. Yes.
Deeply obliged.
May it please your lordship, I am praying for listing of an IA, implement of necessary parties next
Hmm.
week, my lord. Any day.
Yes.
All right.
May I be Lordship? I beg to mention for listing Lordship in WG Lordship, this pension matter Lordship. Lordship, it was last dated on 13, 34, it's on 24 Lordship, long back Lordship. Only next week Lordship. When it-
No, last week of March. Fourth week of March.
I beg to mention item 12 of today's daily list. Lordship.
Hmm.
This matter, some instructions are sought for and I will be filing my wakalat number today.
These are very old matters.
I know Lordship, can it be taken up in the next week Lordship?
No, it
Because
cannot.
those instructions, without those, I think it would be difficult for me to.
On the prayer of Mr. MP Sharma, learned counsel for the petitioner, this matter stands adjourned for 2 weeks so as to enable him to obtain updated instruction. List accordingly.
May please, Lordship. My lord, I pray for listing of the IA in the pending writ petition on Monday, my lord.
What is the matter about?
My lord, in the writ petition, we have prayed for regularization of ours, of our boss. My lord, here, the department, they have initiated a step for publishing, taking a steps, publishing for a,
Next Friday. Next Friday.
on
Put
Monday.
the date of next Friday. Yes. Yes.
May I please your lordship? I beg to mention for listing one writ petition lordship relating to compensation matter. So it was
Second week
last-
of April. Second week of April.
Much
Yes.
obliged.
Yes, your Lordship. That's a prayer for listing on WBC.
Second week of April.
Daily list for admission, item 1.
For my learned friend starts,
Yes.
we have filed an affidavit in this case and the matter is fixed for admission hearing on the last occasion. The other side short time. So I have gone through the affidavit, Lordship. We have found that certain important facts were not placed in the affidavit because the file was with the CID. Now what we are proposing, Lordship, subject to Lordship's approval, that will seek the file from the CID who is investigating the whole allegations of irregular and illegal appointments and file a detailed affidavit in 2 weeks' time, Lordship, subject to what Lordship directs. Lord. Otherwise, the facts are incomplete. Otherwise,
2 weeks. Things can wait. All right. Third, Mr. N.J. Khatania, learned counsel appearing for the lead petitioner.
Oh.
In lead petitioner. You are appearing for the lead petitioner in all the cases.
Yes, not all the cases, my lord.
In
Item 1 and 3, my lord.
You write hard learned counsel for the lead petitioner appearing for the petitioners in the respective lead petitions. Mr. D. Saikya, learned Advocate General Assam, has appeared for the state and submits that although counter affidavit on behalf of the respondent numbers 3 and 4 has already been filed in this case, yet due to non-availability of the relevant records which are in the custody of the CID, complete facts could not be placed on record. Full stop. The learned Advocate General therefore seeks 2 weeks further time to file a supplementary affidavit placing the complete facts on record. The prayer is not opposed by the petitioner's counsel. In view of the above, let these matters be listed again after 3 weeks. In the meantime, the supplementary affidavit in opposition be filed.
Deeply.
7 and 8.
Yes.
May please, Your Lord.
Yes.
In the writ petition, there are basically two prayers. One is with regard to Miller challenge to the show cause notice and another is suspension. So for a challenge to the show cause notice,
Just a minute, just a minute.
I'm sorry.
There are 2 writ petitions.
One writ petition, prayer, there are two prayers, Miller.
So there is a contempt case. Okay.
Sorry,
Contempt case is there.
contempt case is there.
Okay. 1 writ petition, 2
One writ-
prayers.
One writ petition.
Hmm. What,
Two
what is the
prayers.
prayer number 1?
Prayer number 1 is with regard to Miller setting aside and quashing of the show cause notice.
All right.
Second prayer is
Yes.
quashing of the suspension order. Dated 9/2/2023.
Yes.
My lord, will kindly take up the writ petition for a moment.
Yes.
Show cause notice,
Mr.
Your Lord.
Das, just 1
I'm
minute.
sorry.
I'll just go through. Please take your seat. Just
Yes.
1 minute. So some illegal appointments were made
Yes.
when the petitioner was the managing director.
Allegation was that some illegal appointments were made. Those appointments were contractual appointments, not regular appointments. And a committee was.
All right. Where is the show cause notice?
Show cause, my lord, will find page 82. Annexure 6. May I read?
Yes.
You are hereby required to show cause under Rule 9 of the Assam Service Disciplinary Appeal Rules 1964 read with so and so of India, why any of the penalties prescribed in Rule 7 of the aforesaid rules should not be inflicted on you on the following charge based on the statement of allegations attached herewith. That while you were serving as Managing Director MD Assam Fishery Development Corporation from 23/3/2020 to 15/12/2021, you initially appointed, regularized the service of 168 persons as officiating with regular pay scale and also appointed 49 persons on contractual basis. As per the report of the 3-member high power committee constituted by government order number so and so, the persons as mentioned above in serial number 1 were appointed in one of the following manners. A, the aforesaid appointees were from a location near an AFDC bill and got to know the bill manager, started working on daily basis, got appointed on contract, then were asked to officiate in a particular scale and were later regularized in the scale as regular employees of AFDCL, appointed in the above manner, but after working on daily wages contract were let go, then rehired on daily wage contract, asked to officiate, then regularized, appointed on daily wage and then asked to officiate and then regularized, appointed on contract and then asked to officiate and then regularized. In some cases, asked directly to officiate, then regularized. Hence, the appointments were made without following the established procedure rules for appointment in state government public sector undertaking. None of the above mentioned posts were advertised by AFDCL in either official website or any other newspaper through Janasangyog or Employment Exchange, or in none of these cases were any examination dates notified published. Neither any examination was conducted nor any formal notice of interview was issued or conducted. That there is no provision for allowing daily wage contractual employees to officiate in regular post and thereafter make him permanent in that post, and appointment of persons on contractual basis without following normal procedure in a state government public undertaking. That the order of regularization of such appointees with the pay scale was made without taking any consideration the number of vacant sanction posts. Serial number 6 is important. That it is seen that proposals for such illegal appointments had the approval of the board of directors of AFDCL from time to time, and that while the BOD has the power to decide on filling up of the regular vacant post following established norms and procedure, MD of AFDCL cannot back out of her responsibility as provided in the state government OM dated so and so on the plea that such proposal had the approval of the board. Since any such resolution of the board according approval of such illegal appointment is legally not tenable.
All right. Where is your reply?
Let's just pausing here for a moment. So far as Miller challenge to the show cause is concerned, there was no stay order passed. The departmental proceeding continued. And my submission is that at this stage, Milord, the challenge to the show cause notice, Milord, I don't think, Milord, in my humble submission, that survives. But so far as I am basically harping on suspension, Milord. Which was from
No, just a minute.
I'm sorry.
Did you submit your reply to the
Yes,
show?
I submitted my reply, Milord.
All
I
right.
submitted my reply, inquiry was held. That's a different thing altogether. In what manner the inquiry was held. And thereafter, inquiry officer submitted a report, and no opportunity of cross-examination was given to me. Then the secretary again.
1 minute.
I'm
So
sorry.
the inquiry disciplinary proceeding has been concluded.
No, it's not.
Then you
concluded.
say inquiry officer submitted.
And I'm just coming to that, Milord. Inquiry officer submitted a report. That report was, Milord, totally faulty. Then the disciplinary authority remand back again the report to the inquiry officer because no opportunity of cross-examination was given to me at that point of time. Then the inquiry report was remanded back. Then the inquiry officer, Milord, again called me, furnished me the statements given by the witnesses. There were 3 witnesses, Milord, and asked me to cross-examine. Then the petitioner, Milord, she cross-examined, and thereafter an inquiry report is furnished recently, Milord. That is the subsequent.
Recently means, can you give the date?
Yes, Milord, date of the inquiry report. Milord, it was furnished to me on
28th of February. And
No,
she
Milord.
asked for 2 documents. She was furnished with 2 documents on 5th of March. Now we are waiting. Once she responds to this report, then we are going to pass the final order.
Milord.
That is the last stage.
Actually, what happened, the inquiry report was furnished to me on 28th, but it was furnished to me on WhatsApp. 2 pages were missing. So again, I wrote an application to the respondent saying that kindly furnish me that.
So just a minute.
Yes.
We are just trying to understand the
Yes.
case. You make your submissions. I'll hear you. No
Yes,
problem.
yes, Milord.
So this inquiry report of 28 to 2025 has found that the charges are proved against your client?
Yes, Milord.
It has been found.
Yes,
So a copy has been forwarded, but you say it is not complete,
yes,
right?
yes.
So now have you got the complete
Yes.
inquiry report?
Yes,
When did
there-
you get it?
It's on, my lord. Milord, 4th of March. 4th of March, again on WhatsApp, Milord, it was forwarded to the petitioner, Milord.
All right. So
I
now you have received the entire inquiry?
Inquiry report I have
Okay.
received. No,
Now, is there any requirement under the law to wait for some time so that you can file a response to it? Or is the requirement in law only to furnish a copy of the
No,
inquiry?
normally, my lord, 15 days time is given to respond.
That's not the question.
I'm sorry, my lord.
asking, please respond to the question.
Yes, yes, my lord.
Then you can add whatever you want.
Yes, yes.
You are
my lord.
entitled to
Yes,
make
surely,
your
my lord.
arguments.
I'm
There's
sorry,
no
my lord, I
difficulty.
just failed to understand.
The question is there any requirement under the law that inquiry report after it is furnished to your client or whoever the delinquent is, time should be given to submit a representation?
Yes.
Or is it the requirement of law that an inquiry report should be furnished? That's all. Which of the two is correct?
Client should be given, my lord, the petitioner should be given opportunity to submit the representation.
Where is that law?
I'll just place, my lord.
Yes. You're referring to which?
Assam Service Disciplinary Appeal. Rules.
Okay. Yes. Which
I'm
clause?
just referring, I'm just referring. Rule 9,
Yes.
rule 9, my lord will take up.
Yes.
Rule 910, major penalties.
Yes.
Persons got, my lord. If the disciplinary authority, having regard to its finding on the charge and on the basis of evidence adduced during the inquiry, is of the opinion that any of the penalties specified in clause 4 to 7 of Rule 7.
I'm sure even the government departments have missed out on this clause. It is not helping you. It doesn't help you.
I'll
It says it is not necessary. But you see, after the Ramjan Khan's decision,
ECIL will.
yes, that position has changed. Earlier it was that the delinquent will have to be given a copy and an opportunity to show cause. Now the law as it appears, subject to, you may argue
Yes,
if there
my
is
lord.
anything.
Yes.
Now the requirement is only of giving a copy of the report of inquiry officer. That requirement is there, not even there under the
Original.
Yes, under this. But because of Supreme Court judgments, decisions,
Correct.
this is a requirement.
Correct.
But after that, only if the disciplinary authority disagrees with the finding of the inquiry officer, then only you are to give an opportunity. Otherwise, no.
Correct.
So, therefore, the next question which will automatically go to Mr. Saikia is why haven't you passed the final order?
We do not,
You don't have
we are
to.
giving him the maximum opportunity.
No, but then you are creating legal fictions which the courts will have to act on.
We will pass it, Lordship. In fact, it is at the final stage of passing the order.
Have you seen Rule
Yes.
9, Clause
Yes,
10?
and not necessary to give.
And then the problem is the perspectives and views must be there. But when the matter comes to court, the judges will have to go as per the law.
Absolutely.
We don't know what is whose perception, what is the ground reality. We are not concerned. We have to go by the edict of law. That's the problem.
Yeah.
Now, there is already an order of the court that concluded or reinstate. That order has not been complied with. Contempt petition is filed. This is how the matter is before this
And
court.
we have filed a vacating petition because that interim order was obtained by giving wrong statement before the court that no departmental proceeding has started. In fact, at that point of time, already she was examined, she appeared, she was participating full-fledged. That wrong statements, on the basis of wrong statements, the Honorable Court passed that order with the perspective that no departmental proceeding was initiated at all. In fact, at that state, we are at the fag end of the departmental proceeding. That wrong statement maybe triggered the Honorable Court to pass the interim order. And when we came with the vacating
already
petition,
an
that was
application.
stayed.
There is an application for vacation.
Already vacation in there is a favorable order in favor of the state also.
So
That we
that
should
is
not-
now. Okay.
We have done our part, Lordship.
So today, what is to be decided here?
Lordship may close the matter today with a direction that within 15 days time we close the whole department.
That's not at all in the matter of show cause notice, my lord. The show cause notice will take its course. I am on the suspension in the present writ petition, my lord. Prolonged suspension since the year 2023. That too, without review for 90
Right,
days.
we'll post it on Tuesday. Whatever you want to do, you do it before, or Thursday.
One more week, Lordship.
I'm basically on the suspension.
Rightly or wrongly, 15 days time was given to them. That 15 days to 28. Yes, it is already over. It's so she got the complete because on 3rd or 4th, it was on WhatsApp, and next day she came to the office and took the hard copy. So let it after 22nd, 23rd, 24th, Lordship.
Yes.
We want to play a fair game. If Lordship say direct, we can close it tomorrow itself.
My lord, my submission is that so far as DP is concerned, my lord, let it take its own course. I don't have any objection in that. They holding inquiry, imposing any
Where is
penalty.
the IA? Where is the IA?
But so far as suspension is concerned, that is against the law, my lord.
That order was recalled.
Fine, my lord.
Then-
That what
What are these?
I am not insist, my lord. What I am submitting is the lordship will decide the merit of suspension on the basis of law holding the field, my lord. That is the only requirement. That is the only prayer, my lord.
She has already submitted on the basis of the show cause notice and appeared and participated in the whole process. Now that has become defunct. Much water has flown in the river.
I have a right.
Let
to
us,
participate.
please, Mr. Das. What is the issue you want the court to decide?
My lord, the suspension.
Why not the suspension? What meaning does it have?
My lord, the
Suspension cannot be made.
No,
Then-
it can be made.
Yes.
But there are, my lord,
Formulate the issue. What is to be decided by the court?
suspension, my lord, without review within 90 days.
Hmm.
Number one. Number two, prolonged suspension.
Cannot be made. Cannot be made. You came to the court.
No.
The court passed
what
an
my
order.
proposition-
That
what-
order was recalled.
Sorry, my lord.
You came to the court with that plea.
Yes.
The court passed an interim order
Yes.
directing your reinstatement.
Yes.
That order has been subsequently recalled.
Yes.
You have not challenged that.
No, that
order.
was an interim order, my lord.
All right. The final order now, you argue that can prolonged suspension be made when there is an inquiry report which finds the delinquent guilty of charges brought against that person. Argue on that.
Yes, my lord.
Argue on that. Show me the judgment.
Yes, my lord.
Tomorrow, we don't know what action the disciplinary authority will take. We don't know. But now that the inquiry proceeding is complete, now the only thing is for them to pass a final order on the
Lord,
inquiry proceeding.
Just pausing for a moment, my lord.
Yes.
I think, my lord, the charges which were leveled against me and the inquiry decision of the inquiry officer that the inquiry officer has proved the charges has influenced this honorable court that there may be something, my lord, subject to correction. my lord.
You have accepted the inquiry report. You have not challenged it.
No, I'm filing my reply. Recently, I have got the inquiry report.
Then file your reply.
My lord, that is what I'm trying. I'm trying to segregate both the issues, my lord. So far as DP is concerned, my lord, there is a set procedure. Inquiry report was furnished to me, my lord. I'll submit my reply. The disciplinary authority will take a call on the reply and come to a conclusion.
What you are saying is, in a case, and please listen to the query and give your response, because we are also looking at the options. It's not
Yes.
that the court has any preset mindset,
Fine, my lord.
but we will have to go by the legal principles.
Yes.
It can't depend on one fact, this, that, another case, that fact, it can't be. Whatever is decided, it will apply across the board. That you know.
Yes.
So let us assume, don't forget your client's case. Let us assume in another case, employees put under suspension on charges which are quite serious and are capable of inviting a major penalty, including dismissal from service. The proceeding is concluded. The authorities are contemplating what penalty is to be imposed. A few days before that, the employee comes and says, forget what is there. That I am not challenging. But suspension cannot be made because in some judgment, prolonged suspension has been prohibited. Will the court, is the law so stultifying that judges will not see what is happening? The facts of the case doesn't matter. In one case where no progress has been made, the person is simply kept hanging Then the courts will see whether there is seriousness on the department's side. Is it being done only? Ajay Chaudhary also gives reasons why this order has been passed. But in another case where everything is final, concluded, inquiry report there, disciplinary authority is just asking for your comments before taking a final decision. When all these are pending in matters of 8-10 days, the court will say that now reinstate him because the suspended is bad only because one review was not done. Is this how the read court, constitutional courts will function? Is that what your submission is? Then it becomes like a code of civil procedure proceeding.
No.
Then
If I
what is
just-
the legal principle? Tell us
Lord,
that.
The very important word your lordship has said is the charges are so grave.
Yes.
Lordship has, Milord mentioned.
Hmm.
Now this is also a reason by the respondents while reviewing the suspension after the 90 days, Milord. They said the charges are grave and it will be embarrassment for the government, Milord. Now, I'll not take your lordships with the entire DP, what with the evidence and all. I'll take only the written statement I have filed before the disciplinary authority, which will demonstrate who was involved here.
You cannot. That is
No,
not this
that is
case.
for
No,
a prima
no.
facie view of your lordship. No, since this is in.
After the inquiry report has come, whether the charge memo was good or bad cannot be
I'm
gone
not
into.
insisting for that.
You cannot insist.
No, I am not at all. But what I am trying to impress upon your lordships is that, my lord, since they are saying the grave nature of the charges. So since the charges are grave, so I can suspend you to eternity. That is the stand. Now I am entitled to demonstrate before your lordships that actually who are responsible. What is the weight of your charges? Only for the purpose of suspension to decide whether the charges are that much grave that we can prolong him till
So
eternity.
you don't agree with the inquiry officer's finding?
No, my lord.
You have not questioned it.
Look,
That's what I am
the
asking you
procedure-
again and again.
The procedure is that.
That's what I am asking the department whether they want
understand.
2 weeks time.
The procedure.
I don't know.
The
They want to give you a long rope. It is up to them.
The
But,
procedure is that, my lord, I am filing my.
If you
reply.
challenge the inquiry report, then the matter will be very different.
They have recently furnished me.
That's
I'll
it.
submit my reply,
Do it.
and then disciplinary authority will take a call. Look, one thing I'll just point out. Look, it's not that they will come and say today that we are imposing penalty. On what ground?
No, the court cannot say all this.
That's why, my lord, the government is saying that we are going to pass an order as if they are imposing the penalty.
No, who
It's
said?
not final.
Who said they're imposing?
That's what the impression is like that. Lord, we are taking a final call on that.
Final
My lord,
call may be in
whatever-
his favor also, in her favor also.
That is well understood. What my submission? No, when AG says it's my favor, I
It
hope it's
may-
in my
It
favor.
may or it may not. Application of mine will be there.
So what my submission is that, my lord, I am very well aware that what questions I'll face from the court. I'll definitely face the question of gravity of the charges, and I am entitled to try to persuade your lordships that the charges were not that grave, that you violate two major principles of law, that review of suspension within 90 days. Lordship is correct that it is in the eve. The penalty order is in the eve. Why should we interfere? Even that situation also.
It's in the anvil, not eve.
I'm sorry, my lord. It's in the anvil. So in that situation also, my lord, I'll try to impress upon your lordships.
Mr. Das, it is not our job to give legal advice, but it will perhaps be good for your client also. You go back, apply your mind where you stand. Don't get stuck up with one concept that suspension order not reviewed within. It will all depend on the facts of the case. This principle is enunciated so as to protect an officer from undue harassment. That
Another-
principle cannot
another-
be incorporated in a fact
Another
situation like
issue is
this
also
where
that
within next 8 to 10 days, God forbid, your client could be exonerated or dismissed from service.
yes,
So we are not going to pass this kind of orders in vacuum. They have asked for 10 days time, we'll give it. In the meantime, how we want to strategize, you go back to the drawing board, apply your mind. If you want a judgment today, I can dictate, but it may not be good for you. Because every case is to be decided on the facts, peculiar fact situation.
Correct.
Those principles are applicable in cases where you read Ajay Chaudhary twice, see the fine print.
I have seen.
The courts have expressed anguish that relentlessly, countlessly people are being put in suspension, which is a loss to the government's resources. The employee is not getting any unnecessary allowances being paid. The court has felt that it is a pure case of apathy on the part of the department, that they place the employee on suspension and do nothing.
Yes.
So the idea of Ajay Chaudhary is to put in place a system which automatically activates if it is a case of undue delay and
Correct.
harassment. These principles can be not be incorporated to apply in cases like these, where the order by which your reinstatement was directed has been recalled by the court on some reason, good, bad reason, and you have accepted the reason, and now the inquiry report is with you. You submit your response and they will pass an order, which order could be anything. Without knowing the outcome, suddenly in between, we'll say that no, forget whatever.
That order was recalled, Milord, on a different context, that there was
On
a
the request
directive.
of Mr. H.K. Das, learned counsel appearing for the writ petition. You want time or you want judgment to be delivered in this?
Also, will grant them time.
No,
They
what do you want? What do you want? Forget them.
Milord, my prayer is always that it has
Okay,
to be
then
done.
you argue, we'll
Then, Milord,
pass
since
a judgment.
no, let there be piecemeal exercise, Milord. Let them take time for 10 days, whatever they want, let them take it
Mr.
on.
Das, you must be clear in your mind what you want to do. Do you want this matter to be finally heard and a judgment delivered? You want it to be deferred
Take up
for
some
8,
other
10
date.
days?
Also, we'll take up some.
Whatever you want, we'll do it. This
Okay.
debate and discourse is to fine-tune the understanding of legal principles. All right. You are free to argue your case. If you want to argue it today, you argue it. I have not heard you. I have not made up my mind.
I understand.
All I am saying is these legal principles have to be applied by the judges by keeping the impact and practicality in mind.
True, Milord.
Otherwise,
That's
computers will do a better job than us.
That's
Right?
yes.
So, moment a high court passes a judgment in these matters, and this is what is happening. These judgments are used. All right, in a correct situation, it can be. If we find that it is a case of undue delay in proceeding with this court has passed orders.
Yes,
We will
yes.
pass it.
I have got your
We
lordship.
pass it with impunity.
Yes, yes.
But look at your facts. You are just a week away from, could be anything, a catastrophe to something good.
Correct, correct.
And to preempt that, we'll now pass an order that reinstate. The
I
courts
understand.
also see what
understand.
order is to be
I
passed.
understand. No,
We
so we'll
have-
take up after 10 days.
We have our social responsibility
understand.
also. So in that context, you are free to argue.
I understand.
But if you don't understand this concept, then you will go on Ajay Chaudhary, Ajay Chaudhary, Ajay.
I'm
It's
not
a
on-
matter of 30 seconds for me to give the reasons why Ajay Chaudhary is not applicable here. But that's not going to help.
I understand. Lordship,
There
we'll
are
take up
cases
after
where
10
Ajay Chaudhary will apply and we will enforce it, regardless of what the state says.
Yes.
The judges will have to be conscious of the situation of each case. You are not challenging the order by which your reinstatement order has been recalled. You are not questioning the inquiry report anywhere as on date, which records findings of grave misconduct against your client. And you are saying, forget all these things. I ask them to reinstate me. Apply your mind as a lawyer and see what you are asking.
Yes,
Heard
yes.
Mr. Das, learned counsel for the petitioner. Also heard Mr. D. Seika, learned Advocate General Assam appearing for the state on the joint request. We'll make it joint request.
Fine.
23rd, if it is not
Mr.
inconvenient.
Sekia submits that the inquiry report, a copy of the inquiry report dated 28 to 2025.
24th,
23rd is Sunday.
24th.
No, inquiry report dated 28 to 2025.
Yes. I'm sorry, Lord.
Has already been furnished to the petitioner and this department is awaiting her response. As soon as the response is received, the matter will be brought to its logical end. On such ground, Mr. Saikia has sought posting of this matter again on 24th
Of March.
3, 2025. In view of the above, let this matter be listed again on 24th 3, 2025 as a fixed item.
Highly obliged.
You examine your issues in the light of the law and give right legal advice to your clients.
That 28/2, that report dated,
Hmm.
on that day it was furnished to her. That date I do not know, Lordship.
Achha.
It was furnished on 28/2.
Inquiry report which was
Understood.
furnished to the petitioner on 28/2/2025.
Highly obliged.
Item 9.
Yes.
This is a case challenging a transfer orders. Your lordship was pleased to pass certain interim orders. Hello, there is subsequent development.
Hmm.
There is a sorry, man.
Yes, please. Yes.
Your lordship may peruse the order dated 31/2025, my lord.
My lord, there is a subsequent development.
Yes.
And my lord, another impugn order has been passed.
Hmm.
My lord, we have challenged that. That case is before your lordship on Monday as item number 8. I request your lordship, my lord, to take up both the matters together on Monday, my lord.
Yes, my lord, but in respect of this item, my lord, the speaking order has already been passed, my lord.
That is under challenge, my lord, on Monday.
Let the matters
Yes,
come on
madam.
Monday
Fine.
on the joint request of Mr. S.K. Talukdar and counsel for the petitioner, as well as Mr. D.P. Boral and his standing counsel, Health and Family Welfare Department. Let this matter be listed again on Monday, date DDO, to be taken up along with WPC number
1445/25.
1445/2020.
Now, there is an interim order that may continue.
Interim order to continue till the next date.
My lord, obliged.
Obliged.
So what remains? They have passed the speaking order.
My lord, that speaking order is under challenge. They have, my lord, not taken certain considerations, my lord, which has caused prejudice to me. Obliged.
You have to send it to the, send this file to the bench early. Yes.
My opinion. Well, grievance here is that well, in selection process, when EWS certificate was not considered in respect of the petitioner before a lordship. Now, in this regard, they were asked to take instruction.
Instruction awaited, Lordship. He has already offered appointment letter in BSF, Lordship. He was selected, but he was not selected under EWS category.
He has already got appointment in BSF.
Appointment, but he has got appointment, but he has not joined.
Why?
He has not joined. My lord, after if my lord his EWS status taken into consider, he would have selected in my lord CISF. So in that choice, he's decided to invoke. My lord.
So now if he doesn't succeed here, gone. Why he did not join? He could have joined and without prejudice, we could have challenged.
But he has
Now if he doesn't succeed here, he is lost. He doesn't get anything.
not seen.
So there is no urgency. We'll hear the letter of
Instruction awaited in this why EWS transaction.
Heard Mr. K. Raman, counsel for the petitioner, also heard Ms. S. Barwal, RSCGC, appearing for the state, for the respondents who submits that the instructions as called for are still awaited, and therefore the matter be posted again after 4 weeks. The learned CGC has also appraised this court that pursuant to the selection recruitment process initiated by employment notice dated 24/1/2023, the petitioner was issued appointment letter for joining the Border Security Force (BSF), but he has declined the same. Full stop. Responding to the above, Mr. Rahman submits that since the petitioner was interested to join only the CISF, hence he did not accept his appointment in BSF. Be that as it may, since the petitioner is not willing to accept appointment offered to him by the authorities based on his merit position, this court is of opinion that there is no urgency in the matter. As such, this writ petition is directed to be listed again after 6 weeks. In the meantime, the respondents may file affidavit.
Obliged.
Supplementary list for admission item 30.
Yes. Yes.
In this case, I have just received 3 days back the record of the inquiry report, my lord. If it is not inconvenient to your lordship, it can be taken up on Monday, my lord. This Monday.
Miscellaneous day.
It might get necessary. Otherwise,
Tuesday then, Monday
Tuesday.
not.
Yes,
possible.
my lord.
Mr. mm, GK Gupta, Learning Council is present for the. We'll have it on Wednesday then, Wednesday. Present for the writ petitioner. Mr. BK Singh, Learned Standing Council, FCS submits that he has recently received the records, but could not go through the same due to paucity of time. On such count, the Learned Council for the respondents has prayed for posting this matter again on 19/3/2025. So the prayer is not opposed, same stands allowed, list accordingly.
Obliged, my lord.
Is your lordship. Here the petitioner is the senior surgeon of the Silchar Medical College. And his name was removed from the register of Council of Medical Council, my lord. On the basis of an inquiry, your lordship may kindly see the impugned order at page 29, my lord. Annexure D. On the very first sentence, it includes that after due inquiry, it was found that so and so there is negligent in his special care.
Where is the impugned order, page?
This impugned order, Annexure D, page 29. The very first sentence states, my lord, after due inquiry, found that Dr. Afsar Alam neglected in his patient care, my lord. This inquiry report is at page 76, my lord. Page 76, that is the respondents had annexed in their, my lord, affidavit in opposition.
1 minute, 1 minute. Yes.
Here in 2018, one patient died after cesarean operation. It was done by a team of doctors, my lord, not the petitioner alone. And it is clearly reflected in the inquiry report itself. at
Where is
page
it? Inquiry
76
report, page?
Page 76, my lord. That is the annexure of their affidavit in opposition filed by the respondent. Page 76, running page. And the relevant is portion is para 3, analysis of the case and view of the inquiry officer thereof. Roman 3 is the relevant, my lord. On 7/8/2018, she was brought to OT table and accordingly OT started at approximately 11:55 AM and a baby delivered through so and so. But like other similar post-operation patients of maternity, she was not shifted to ward, rather she was under observation as reported by attendants of the deceased as well as the concerned doctor. During course of inquiry, it was reported that more than normal so and so and the by the my lord, and the last 3 lines I am reading by the was performed emergently at around 2:45 PM by the team of doctors under the leadership of Dr. Afsar Alam Laskar in order to save the life of the patient, as there was no other alternative way out to stop bleeding as stated by the team of doctors during inquiry. In post-operation, the patient was kept in observation again and the patient's vital were stable as stated by doctors, and hence at 5 PM she was shifted to ward bed number 10 with normal pulse and BP 110/90. Subsequently, patient developed respiratory distress and her condition became deteriorated. In the meantime, Dr. Alam checked up the patient and one child specialist, Dr. S.K. Rao, was on duty at around 9:30 PM when examined her pulse and BP were not recordable, immediately doctor suggested for ventilation and referred to Gracewell Nursing Home due to lack of ventilation facility at Civil Hospital, Silchar. And thereafter, at 10 p.m., the patient was shifted to Gracewell under Dr. Ray and Majumdar. So it clearly reflects that a team of doctors were involved and they tried their best to save the patient. So there is no medical negligence on the part of the petitioner, my lord. On the basis of this report, they have, my lord, removed the petitioner's name. And this inquiry report was also not furnished to the petitioner. It is clearly reflected at page 81, my lord. Your lordship may kindly see the copies served to my lord. Page 81, my lord. Copy 2 at the bottom, my lord.
Yes.
It was served to Dr. Atul Kumar Kalita, Gopal Chandra Das, Arunodaya Goswami, and so, my lord. It was not furnished to the petitioner. So on the ground of medical negligence, his name was removed, but there is no medical negligence on his part. He tried his best to save the patient and he was not alone. A team of doctors were involved. It is reflected clearly in the inquiry report itself, my lords. And here, my lord, I have also annexed one.
All right, so on what ground are you challenging this order? Page 29. What is the ground?
Ground is that, my lord, a team of doctors were involved. Petitioner was not alone. And as per the
No, that
MPO
cannot be a
report,
ground.
they have
Cannot
only.
be. Please listen to the question.
Yes, my lord.
This is a forum to deal with issues legally. There is no point, just saying no. Team of doctors were there is not a ground. You have to tell me what is the ground on which you are challenging this order of 29.
Yes, ma'am. The
If
petition.
your ground is that it is a perverse order, say that.
Yes, my lord.
Then we are saying team of doctor and all, that's not a ground.
My lord, as per the impugned order, only the petitioner performed the operation and there was negligence on his part.
Yes.
So there is no negligence on his medical negligence is that if he refuses to provide treatment or if he
No,
provides
you
wrong
expect the
treatment.
read court to go into whether there is negligence or
No,
not.
my lord, and
Then-
moreover, no inquiry report was furnished. Moreover, my lord, he was not even given opportunity to examine
Say
witnesses.
that.
Yes,
These are
my lord.
relevant arguments.
He
You
was
are
not-
going in a direction
Yes,
where
my lord.
the only option is to dismiss your writ petition.
My lord, the petitioner was not allowed to examine any witnesses. He was also not allowed to, did not give any opportunity, my lord, to produce his own evidence, witnesses, my lord.
Yes.
My lord, the experts
Only,
has
only tell us, this is a order passed which has adverse civil consequence of on the petitioner.
yes, my lord.
His license is withdrawn, so he cannot, his livelihood has been taken away.
Only for 6 months.
Listen, listen.
Yes, my lord.
You may be right, you may be wrong,
Yes, my lord.
but the 6 months is not expired.
No, my
Yeah,
lord, it will
it will,
expire on April, my lord.
April.
But it will remain as a stigma for his whole, my lord, professional career.
But if we set aside, we'll give them time to initiate a fresh exercise. They will again suspend your license if they want. Another 6 months. You want that? Then you wait till the exercise is done, then we'll see. When does the 6 months come to an end?
My lord, it was issued on 25/10/2024. So, so it will expire on 24/4/2025, my lord. You know?
No, but the petitioner received on 5/11/2024, my lord.
Ms. Chaudhary, please understand the query of the court.
From the date of receipt.
Listen, if your ground is that he was not given an opportunity of being heard, and if it is established, we'll set aside the order. But then they will have a chance to start the process again. In that process, after giving you an opportunity of being heard, it is up to them either to exonerate you or to impose a fresh penalty, which will prolong your thing further. Do you want to expose your client to that? Then what do you want today?
My lord, my humble submission is that since they have not followed the due procedure, my
All right, on the prayer of Ms. S.B. Chaudhary, Learned Counsel for the petitioner, you have not even thought about these things. You are just saying things, humble submission, humble. Your submission is that you want the matter to be posted again on 24th of April. That's what I'll reckon.
No, my lord.
Then
My lord, my prayer is for setting aside the.
we'll set aside, give you liberty to initiate fresh proceeding after serving notice upon him.
My lord, the inquiry was conducted by a magistrate, my lord. That was a.
But was he served notice? Was he given an
My
opportunity?
lord, I am not representing the magistrate, my lord, because on the basis of the magistrate inquiry report, my lord, the council has taken a decision, my lord.
Correct, but if the magistrate's inquiry is found to be in violation of principles of natural justice.
But my lord, it says that the statements were recorded, my lord. But the subsequent portion of the inquiry report, my lord.
No, her plea is that the inquiry was committed behind his back.
It was a, my lord, open inquiry because magisterial inquiry was ordered, my lord. So it was not done by back of any person, my
No,
lord.
but fine, but on the basis of that inquiry, if you want to take action,
Yes, my lord.
the person is not entitled to an opportunity.
Yes, my lord. He was issued notice, my lord.
Where is
he
that?
has appeared, my lord. My lord, page my lord, 74, my lord. Which refers to the subjects mentioned above, you are page 74, annexure 1. Annexure 1 of the affidavit filed by the respondent number 6, my lord. He has duly appeared before the council, my lord. You were directed to attend the office of the Registrar Assam Council of Medical Registration 6 Mile Khanapara, Guwahati on 19/7/2019 at 1 p.m. with all relevant documents and give your reply to the complaint made by so-and-so, my lord. My lord, then he submitted an application which is in the next page, my lord, so that on that particular date he cannot appear. Subsequently, he was allowed another date, my lord. And
So he was heard.
Yes, my lord, he was heard.
Only he submitted his documents, my lord, but he was not allowed to, my lord, examine evidence, but they have taken evidence of other doctors also.
No, but have you
That was
you
not
written
done.
to them that
That was not done during inquiry. This is not during inquiry.
have
Inquiry
you
report was
made a request that
inquiry is done in 2018, my lord. This is of 2019.
have you requested the authorities to allow you to adduce evidence?
Yes, my
Where
lord.
is that document?
That is, my lord, when he received the notice, my lord, the latest, last one, my
Yes,
lord.
yes. Show me
He
that
submitted
letter.
his reply, then he said, my lord, he submitted his reply,
Hmm.
the last.
Where is that letter by which you wanted to?
28, page 28, annexure C, my lord, of the writ petition.
Yes. Page 28, annexure
Page
C.
28, my lord, allegation against Dr. Afsar Alam, alleges so-and-so. With reference to, I am to inform you that you are directed to appear in the council by letter so-and-so. So on receipt of this letter, he appeared, my lord. He appeared and submitted his reply. And they assured him that, yes, after receiving the reply, you will be given the opportunity to examine witnesses.
Ms.
But
Chaudhary,
nothing was done. Subsequently, simply they
I
passed the order.
understand simple English. Okay. I have asked a simple question to you that has your client made any representation before the authorities that he wants to adduce evidence in his defense? If it is there, please show me that letter.
My lord,
Why are you going here and there?
My lord, after his reply, this impugn order was issued, my lord.
Which reply?
My lord, annexure C, page 28. This is the notice he received, my lord.
Yes.
Then after that, he appeared and
He did not
submitted his
appear.
reply. Submitted his reply.
Where is his reply?
Reply I have not annexed it. It will be in their record. Then on
You have
your
the
lordship,
records.
on
Right now, I
Get
don't
the records, then we'll have
they
to see.
simply issued this order, my lord.
The
They
records, then
removed
we'll
it,
call
my
for the records. You have not given the complete documents.
My lord, the copy is not available with me, my lord.
Then you produce the
It will
records.
be in the record, my lord.
When you can produce?
My lord. Next week, my lord.
You choose a date, next Friday?
Not next. On 26th of March, my lord.
Yes. We have to see the records because your
Yes, my lord,
submissions
that
are borne out.
reply may be perused, yes, my
Yes.
lord, reply will
Yes,
be
madam.
available with them, my lord.
Yes, my lord, I will obtain the record.
Heard Mrs. B. Chaudhary, Learned
He has
Counsel
given his
for Petitioner.
explanation.
Also heard Mr. D.P. Bora, Learned Standing Counsel, Health and Family Welfare Department, Assam, appearing for the state respondents. The petitioner's counsel has argued that despite seeking opportunity to adduce evidence during the inquiry proceeding, no such opportunity was granted to him by the authorities. However, there is nothing on record to show that the petitioner had in fact made such a request. Situated thus, it would not be possible for this court to appreciate the said submission, which might have a vital bearing in the outcome of this writ petition. Mr. D.P. Bora, Learned Standing Counsel Health is therefore directed to produce the relevant departmental records on the next date fixed. This case again on 26th of March 2025.
Obliged, my lord.
Like.
Yes.
Actually, as for last order, some Provo is there.
Here I claim, my lord, let it be taken up on, my lord, Wednesday or Friday next, my lord, I will come up with everything, my lord. My lord, these officers are not there now, my lord, but we have communicated. In fact, my lord, on the day when the contempt was closed, my lord, the DP was concluded, and my lord, it was forwarded to the Assam Public Service Commission for their consent, as per the rules, my lord. He is a gazetted officer. Thereafter, my lord, what has happened, not known.
Contempt was closed means the contempt. This is the contempt case.
No, my lord, Lordship will see one order, my lord.
Page number 25.
25.
Earlier I have. But there is no further extension also there, whether they have taken any extension after 45 days, so kindly see.
Page number
25.
25, my lord.
25. The order is 7/11/22, Lordship. Given on 45.
So now the departmental proceeding has been concluded.
No, my lord, on the day, my lord, when this order was passed, that was our submission. In the last phase, we are waiting for the APSC's approval. So far as I remember, my lord, I'm waiting for the written instruction to be placed, my lord.
So in this case, which order violation of this order is complained? 7/11/2000.
Page 16.
Page 16.
16, the relevant part.
What is this order? Page 60.
It starts from, my lord, page 13. The relevant will be
16,
16, last portion. In view of the reasons stated above, this court direct the state respondent, especially the respondent one, to complete the departmental proceeding pending as a petitioner within a period of 3 months from the date of receipt of a certified copy of this order. Thereafter, the respondent one shall consider the petitioner's representation for voluntary retirement and shall take a decision thereon within a further period of 1 month. So what action?
I was suspended in 1998, Lordship, already 25 years, Lordship. And this order was passed 7 years ago, Lordship.
All right. We'll fix the matter on 24th, but we'll make it clear that no further time under any circumstance will be granted to the respondent's counsel. Heard Mr. 24th of March.
Yes.
Heard Mr. A.U. Ahmed, Learned Counsel for the petitioner. Also heard Mr. B. Gogoi, Learned Standing Counsel, Health Department, Assam, who seeks posting of this matter again on 24/3/2025, so as to give one last opportunity to him to seek instruction as per the order dated, as per the earlier order passed by this court. Prayer allowed as last chance. It is made clear that on the next date fixed, no further time will be granted on.
One more submission, the officers, my lord, who are presently respondents in the contempt case, they are not there in their post as on date.
No, but
I will furnish the instruction from the department.
No further adjournment will be granted.
It will give us.
Yes, what is the matter?
But it's a matter regarding the higher wages of the casual worker engaged in the Jilla Parishad. Pursuant to the letter dated 25/1/2012 issued by the Joint Secretary to the Commissioner, but the government had decided to give the higher wages.
So what is the wage you are getting now?
My lord,
What is the wage you are getting now?
Well,
Your client is working as what? Night chowkidar.
what is night chowkidar, casual worker under Dorong Jilla Parishad.
And what wage is he drawing now?
My lord,
How much money?
well, now at this stage, well, I could not contact with him.
Hmm.
But earlier he was got the 4,000 something. Well,
So 4,000 will not do. Now it is must have been reviewed.
yes, well,
Then unless you tell us what.
sometime maybe given, I will contact with the client, well, of the recent salary. Well, because yesterday I
Ganahar
tried,
just-
well, but could not contact. His phone number is there.
Counsel for the petitioner also had Mr. S. Datta, Leonard, Standing Counsel, PNID Department, Assam, appearing for the state. The writ petitioner hearing is a casual employee and presently serving as a night chowkidar in the Darang Zilla Parishad. Full stop. The grievance of the petitioner is that he is being forced to survive on a meager, meager wage. Although similarly situated persons have been the beneficiary of reversed wage. Full stop. Mr. Islam could not, however, appraise this court as to whether, since the filing of this writ petition, when the monthly wage of the petitioner was rupees 1,000, was rupees 4,000, any further increment in the wages of casual workers such as the petitioner has been made by the department. It was 4,000 while filing it, is it?
Yes, yes.
Although this is a old matter pertaining to the year 2014, yes, in the absence of concrete instruction, the prayer made in the writ petition cannot be considered. As such, let this writ petition be listed again in the next week so as to enable Mr. Islam to obtain necessary instruction.
Much of it.
May it please your lordship, your lordship, on the last occasion, the reply that affidavit in opposition what they have filed, they have said that they need 6 weeks time to clarify what the petitioner has to be get. But till now, we have not got any reply, anything, any output from them, your lordship. So the
proceed with the hearing. We'll proceed
yes,
with
your
the-
lordship. Uh,
Where is your representation dated 2/9/2013?
uh,
Page number 26 of the writ petition.
No, what has happened in this case, a departmental proceeding was,
No, no, your lordship, already judgment has been passed and punishment has been confirmed by the Honorable High Court in the writ petition. Thereby, that removal from the service was upheld. Thereafter, the writ petitioner's pension, gratuity and leave encashment was due to pay. And against the pension, we have stated in our affidavit that Rule 22 of the pension rules, they are not entitled for any pension. But in regarding to the gratuity and in regarding to the leave encashment, since the matter belongs to 2012, so we could not able to find the records. For that, we seek 6 weeks time. But in the meantime, I have not taken the instructions today itself, Your Lordship.
Your Lordship, my counsel, senior counsel is also out of station, so may it be.
then you seek adjournment.
Your Lordship.
The learned counsel for the petitioner submits that the engaged senior counsel in this case is out of station and therefore hearing of this matter be adjourned. Mr. M. Sharma, learned standing counsel for UCO Bank, has also submitted that some instructions are necessary pertaining to the prayer made in the petition for release of leave encashment and gratuity. But since the records could not be traced out, the necessary instruction was not furnished to him till today. On the joint request of learned counsel for both the sides, let this matter be listed again after 6 weeks for hearing as a fixed item.
Item
16.
May I?
Hmm.
Lordship, entire matter has attained finality by the division bench, Lordship, in WS 73/2. The issues raised in this present petition.
Just 1 minute. Take your seat, take your seat. I'll just. Acha, Mr. Arbu, is this matter covered by the division bench judgment?
Covered, my lord, the only difference is that, my lord, in the division bench matter, my lord, the incumbent was a sub-register. He was appointed on commission basis. Later on, he was, my lord, regularized. Then after regularization, my lord, he claimed that he is entitled for, my lord, under the new old pension rules. So therefore, my lord, his past services has to be counted. Now, whether his past services is required to be counted or not, that was the precise issue. Now, he was appointed, my lord, that incumbent, Hussain Ali, was appointed in the year 1984 as a commission basis register. It's a part of this record also. On being appointed as such, he in turn has appointed the petitioner on commission basis as LDA.
When?
He was appointed, my lord, the petitioner was appointed.
1984.
My lord, it is on 31st May 1984. That lordship will find at page 26, Annex 3 of the writ petition. And thereafter, my lord, subsequently, page 39, Annex 6 of the writ petition, my lord, this particular petitioner, as well as, my lord, his employer, Hussain Ali, who was a sub-register on commission basis, both of them were regularized. Now, having been regularized, there was a condition, my lord, in that regularization order, if lordship pleases to see page 39 of the writ petition, there was a condition that they will have to give a undertaking that they will be covered by the new pension scheme. Because he was regularized, my lord, by order dated 25th of April 2008. By that time, my lord, the new pension scheme has already become functional with effect from.
So that was the case of for the appellant for the writ petitioner in the other matter also.
Other matter.
So then it's covered.
Appears to be covered.
Then appears to what? You have to say you are the counsel.
But the only distinguishing factor is that, my lord, that person, my lord, that Hussain Ali, he was appointed by the government on commission basis. And there was a, my lord, clear instruction to him only to set up his establishment. There was
But
no
you have regularized his service.
regularize his service, my lord. Maybe, my lord, regularize his service. So he will be getting, my lord.
What
new
may
pay.
be? Once you regularize his service, what process you have appointed, that you cannot question now.
No, my lord, because he will be entitled to new pension. It is not that, my lord, he will be deprived of any pensionary benefits. He will be entitled to pension, but albeit, my lord, the new pension.
So his contribution is being deposited.
That instruction I do not have, my lord.
No, but if it is not being, Mr. Islam, when I ask you a question, you will not be able to answer. So don't jump around. Let us take your argument to be correct. Even then, new pension means the contributory
Yes,
pension has to be
contribute. It is
deposited.
just like provident fund.
It will accrue interest, etc. Have
Absolutely
you
correct.
maintained that account?
That, my lord, on facts, I will have to take instructions.
If you have not maintained that account, you cannot do it today.
Yes, yes.
That you agree?
Yes, yes, Lord. Estoppel will operate against me.
And only if it is a case of regular old pension scheme, there is no need to deposit. Otherwise,
No
under
need
the
to
new
deposit.
scheme, if you have not deposited, matter ends there.
Yes. To that extent, my lord.
And he has to deposit his part.
Yes, definitely.
So has it been done?
That on facts, my lord, I will have to take an instruction because his repetition is also silent, my lord. I can understand, my lord.
Has your client made any deposit of contributory provident fund?
No, I am not taking NPA.
That instruction you have?
Yes. I have not, till that I have retirement 10 years already. I have not taken that.
You have retired 10 years back?
Yes, 2015. Retirement letter is Annexure 10, page 69. 10 years back. I was waiting only for the division bench, single bench, division bench, then Supreme Court also point.
You went to Supreme Court against this order.
Supreme Court, my lord, our initial appeal was, my lord, dismissed on the count of delay. We went to the Apex Court. Apex Court imposed the cost of rupees 25,000, remanded back the matter. We strenuously argued before the Honorable Division Bench of this Honorable Court, and, my lord, our lead appeal was dismissed. And, my lord, he has that earlier person, my lord, that commission machine sub-register, he had filed contempt, and finally the contempt was closed, my lord, and he had got all his amount. But the only distinguishing factor here is that, my lord, that the government has taken a decision, the state has taken a decision to appoint that person on commission basis. Here is a case, my lord, that person in turns appoints him.
Correct, but government has regularized his appointment.
Regularized him, my lord, but whether his past services would be, my lord, would be counted for the purpose of giving him the benefit of 1969. So that argument is still
So
open.
which pension is he entitled to according to you?
New pension.
Have you deposited the amount?
To that extent, my lord,
If you have not, you cannot argue.
Yes, absolutely.
Fixed parted matter on 25th. So as to enable Mr. R. Babujari, learned counsel for the state, to obtain specific instruction and appraise this court as to whether any account of contributory deposit under the NPS in respect to the petitioner has been maintained by the authorities, and also on the question as to why the petitioner's case should not be, and also address the court on the question as to why the petitioner's case should not be held to be covered by the judgment dated 12/5/2023 passed by the division bench of this court in readable number 73 of 2019, bracket State of Assam versus Mohammad Hussain Ali. Fixed parted matter on
25th. 25th is Friday, Lord. Let it be on 24th.
25th is Friday.
Oh,
You are
March
looking at Supreme Court.
25th. Sorry. I have seen April one.
You have seen calendar of which year?
Lordship, I have seen April month. It is the month of March.
April.
Please.
Okay.
I'm so obliged, my lord.